Step 1, wake up, really gonna rise with the sun. Step 2, get some good, some food in you. Step 3, think real hard about what you wanna be. Step 4, fuck everybody, just do your thing.
Wake up, today's gonna be a good day. 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 Yo, set your affirmations, aspirations. I got shit to do, the aftermath of preparation. Good food, good mood, blood in circulation. One step at a time, yeah, that's how you make it. Set a goal you control and the steps you take them. I try to pick one thought, have some concentration. And if I make a mistake, it's called education. I try to do this every day, call it replication. Wake up, today's gonna be a good day. 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 So life ain't easy, yo, I think there's a reason though. Ups and downs, just like every different season, yo. Sometimes I'm high, other times I'm barely breathing, though. I always gotta fight and hide from the demons, yo. Negative thoughts are poison, they rot. Head full of flaws, so here come the clouds. They'll never stop unless I can swap all the bad for the good in my head when I'm lost. Yeah, so I'ma fake it till I make it. Positive thoughts are overtaken, I got patience. One day at a time is how you operate a cadence. A flow, you grow, you show yourself a foundation. Stay away from all the shit that causes temptation. I know that I like to do it cause it's sensation. I live my life in my head like a narration. Don't expect greatness, do my best, man, I'll take it. Wake up, today's gonna be a good day. 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 Wake up, today's gonna be a good day.
Wake up, really gonna rise with the sun. Step 2, get some good, some food in you. Step 3, think real hard about what you wanna be. Step 4, everybody just do your thing.
I'ma say this right here, baby, because some of y'all be acting like y'all don't be seeing it. But, baby, playing victim in a situation that you created, oh, yeah, baby, that's narcissistic as hell to me. Hello, somebody. How you gonna create the storm, then get mad when it rain? How you hurt somebody and then get mad that they hurt? How you damage somebody, go outside your way to destroy a person and then get mad when they no longer want to deal with you? Baby, playing a victim in a situation that you created, oh, baby, that's narcissistic as hell to me. I'm sorry, but it is.
I don't enjoy hurting people. I don't enjoy seeing people hurt. I don't enjoy saying things that make people feel bad. That isn't inherent to who I am. But I value truth and love more than making people feel good temporarily. That to me is a bigger issue. And it's simple. Would I want somebody to tell me what I wanted to hear if it wasn't the truth? No. I'd be pissed. That's not my friend. My friend tells me the truth first. That's what I want in my own life. Good friends, tell me that. I'm more concerned if you're afraid to tell people the truth because of what they think of you. Like, what kind of friends do you have?
Welcome to the Bullhorn Betty Coffee Club.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.
You guys are gonna kill. Well, guess what? We got light, right? We haven't seen light above Bullhorn's Betty's head since before Ian. Hurricane Ian that hit Florida. Just got the roof done. Just got the fan done. When I pulled the fan down, there's a box in there. And now I don't know if it's the relay box. I'm not all techie. I once upon a time knew all this stuff, but I don't know. And I believe it was the relay box. But this is a little box inside there. When you guys saw the big holes in the ceiling, well, that's because it's plaster. I've got about this much plaster on that ceiling, and it's hard to find the studs. So you have to use these special screws that have this like spring clamp on it. It goes up in the holes and then it springs out, and then you screw it up and clamp it. It's kind of clamp. So anyways, when the roof was coming off, it was apparent that water, came in through those little holes and got into that area and must have burnt it out. But I kept smelling smoke. Remember back then I kept saying I had to turn it off because I kept smelling smoke. Well, this thing was fried and melted. It was bad. And as soon as I started undoing it, the more I could smell burnt wire. And I'm like, I'm so thankful I did it. But we got light now. We got a Hunter fan. It is installed. No wobbles because I'm awesome. And it's up. And I got to say, I cussed quite a bit putting it up because I knew a normal fan takes about 2 hours to put up, right? I put up hundreds and hundreds and hundreds of ceiling fans over my years. And I've got to tell you that this fan, I guess I forgot how long it took because I'm like, why is it fighting me? I have fun. What can I say? Left to my own devices, I have entirely way too much fun when you guys aren't looking. So the real me too. Good morning, Akita lovers. CA is in the house. Jennifer. It's nice to see you, love bug. I missed you, by the way. I was going to call you yesterday, and right when I was going to call you, then I got sidetracked and I forgot to call. So I apologize about that. Good morning, by the way. MJ in the house. It's nice to see you. Patricia Miller. Who else do we have? Sonia. Good morning. Good morning. I still have to do design. I will do it. I think I'm going to get it done today. Hopefully. We'll see. Procrastinator right here, right? Angie, it's nice to see you. Who else do we have? Huntress. Nice to see you, love bug. I hope everything is going well for you. Oh, Lady O, good morning. Good morning. Shannon, it's nice to see you. I didn't call you Sharon today. Oh my God, I got to tell you guys something. So I had a friend. I haven't talked to her. Well, I did talk to her like in the last year, but it's a friend that I've known for years, hung out with her for years. And over the years, having families, getting married, her having kids, she's one of those women that was in a very violent relationship with her daughter's father. And he tried to unalive her. And she ended up pressing charges. He went to jail. And while he was in jail, he was plotting on what he was going to do when he got out of jail and got in trouble yet again. So there, I do understand the gravity to, the bad outcome that could be achieved in domestic violence. I've known people that have lost their lives in domestic violence. I've known people that have thrown people in jail for domestic violence. And I know how important that support system is during the entire process. Anyways, long story short, it comes back to Sharon. I remember when her daughter was born. I'm not going to say her name. I remember when her daughter was born, they were going over names, and the father, his mother was named Sharon. And so Sharon's something else because she was the grandmother. So she had a different last name, and he wanted to name his first daughter after his grandmother, Sharon. And I remember my friend saying, there is no way I'm calling my daughter Sharon Peters because their last name was Peters. She said, I will roll in my grave before my daughter is named after your grandmother. It is not happening. And it's like, you don't think of that, but I'm thinking, oh, Sharon's a great name. Why, Sharon's a great name. She ended up going with an S name, but not Sharon. I don't know where that story came from. It just popped back into my brain, but I remember having those conversations during her entire pregnancy because I was there when that baby was, well, I wasn't physically there when the baby was conceived, but I was in the area when the baby was conceived. Like we were at, what was it, Rockfest or I can't remember. I think it was Rockfest. We were at one Rockfest and things got a little carried away between a husband and a wife. What can I say? They ended up conceiving a baby that night. I was not there, but I was in the general vicinity because it was Rockfest and we were all pretty much in the general vicinity because we were all camping. So I was there when she was conceived and I was there when she was born. And all the stuff in between. But I just thought that was a funny little story. Anyways. Sean, it's nice to see you, Love Bug. I hope you're doing well. DB, nice to see you. Kathy S. TLC, Belinda, good morning. Good morning. Who else do we have? Brittany Blue Eyes, it's nice to see you. Misty, good morning, love. Good morning. Good morning. Let's see. Who else do we have? Amy is in the house. Nice to see you, love. And you know what is really cool, Netelle, good morning, is I don't know how many guys remember It's Me, Angela D. She used to be like the right hand of Dolly Vision, you know, for golly, ever since I can remember. I know that she wasn't there always, but I haven't known Dolly always, right? I've only known him in the last, year and a half, 2 years. And so you guys know she had a stroke and was no longer able to help Dolly because she was going through a lot of recovery. Well, bless her heart, I saw her in here the other day and I didn't get an opportunity to give her a shout out because I didn't realize she was here until after I closed my live and did a review of comments and whatever was going on in here. And so I was just really, really, my heart melted to see Angela D kind of, you know, out and on the streets of YouTube again after she's been through such a medical issue. Many of you guys don't know our beloved Sepsis Kills is not doing well. She was back in the hospital and she was back in the hospital on her birthday, which really sucked. So just keep people in your prayers, guys, because, you know, all of us go through something. Sometimes it's medical, sometimes it's not. But on the lighter side of things, right? On the lighter side of things. So you guys got to see this. By the way, thank you for your super sticker, Sean. God bless you. God bless you. So somebody sent me this, and it took me a minute to figure out what it is. I'm like, okay. They sent me this message and basically said, oh, this is so funny, you know, laugh emojis. And I'm like, okay, is it my facial expression? Like, why are we having some issue with this right now? And then I look above and it says missing woman Miranda Rodriguez remains found in barbecue pit. And then right under that, it says, oh my God, need I say any more with my ribs? And when I saw that, now granted, you know, true crime, there are victims, but it is so funny because this is hilarious to me. I mean, it is hilarious to me. Now, granted, we're not making fun of the woman's remains found in the barbecue pit, but for comedy purposes, this is hilarious. And so they sent it to me and I couldn't help but to chuckle. And, and like I said, it truly did take me a minute or two before I got it because I was just looking at my picture. I'm like, what? And then I finally read the comment up above and I'm like, OMG, I cannot believe it. And sometimes I think YouTube puts things in positions like that on there to get people's attention. I don't know. But either way, I took it. When I started laughing, There's no ifs, ands, or buts about it. It was hilarious to me. So we're going to get on to the language of letting go, another kind of long-winded, hold on, let me find where my page is. Another long-winded, there we go. All right, I'm back to where I need to be. A long-winded message today, but that's okay. So July 28th, turn the switch on. Many of us had turned off the intuition switch of our sense of knowing the truth. We may have turned it off when we were children because our parents lied to us, or we may have turned the switch off later in life to be in a relationship to people who were lying to themselves and us. Our inner voice, our sense of knowing the truth, had to be turned off in order for us to remain in the situation. It's time to turn the intuition switch back on. Go into your circuit breaker room and turn it on. You know you can feel it when somebody is lying to you. You may not know it right away, but you can tell before long. You know if you trust you or mistrust somebody. You probably know the truth right now about how you feel. Can you trust yourself? Stop doubting. Begin trusting and listening to what you know is the truth. You know when a thing feels right to you, and you know when it doesn't. The problem isn't your intuition doesn't work. The problem is sometimes you choose to ignore it. God, help me listen to when you speak. Help me trust the radar you've built into me. Here's the activity. This is a meditation to help you activate your intuition powers. Get yourself into a relaxed position, either sitting or in a comfortable chair or lying on a couch. Spend a few minutes consciously relaxing your entire body. Start with your head, your face, then move downward to your toes. Then picture yourself at the bottom of a staircase, standing in front of a door with your name on it. Open the door and go into the room. In this room are a lot of switches, similar to a circuit breaker room. Look for the switch marked intuition. See yourself going over to the switch and then turning it on. If it needs to be repaired, see yourself making those repairs. If you have difficulty turning it on, ask what the problem is, what you need to clear up before you can turn it on. Once the switch is turned back on, leave the room. Lock the door behind you, then walk back the stairs and slowly back into awareness. Whenever your intuition falters, check the switch in your switch room to make sure the switch is on. I thought that was pretty interesting. A lot of people, we talk about that internal feeling, that internal voice that screams to us sometimes, and we know it's there, and sometimes we choose to turn it off. We choose not to listen to it. We choose a number of things, but one thing we choose not to do is have anything to do with this intuition, especially when we don't want to come to realization that our partner, our friend, our children, our boss is lying to us. Our family is lying to us. And we have this way of saying, we don't want to believe it. Look at Carly Russell's family. I would say their intuition switch has been turned off, and has been turned off for many years when it comes to their daughter. So, we have to look at those things. But again, it's all about empowering you. We have to make decisions for ourselves. And if we're very unhappy, it's up to us to find out what's going to make us thrive and make us happy. So, and that's different from person to person. What works for me and what's good for me in my life may be horrible for you in your life. So, be responsible and realize not everybody's destiny, not everybody's job, not everybody's thing is going to be something you agree with. And that's okay too. That's not your business. So getting to the meat and potatoes of our conversation today is going to be obviously going over the Bryan Kohberger case, the new filings. We had a kind of a treasure trove. Gotta drop my daughter off at work. Be back in a little bit. Okay, Misty, well, you take care. Drive safely. Mama Bear of 10, good morning. Good morning. I hope you're doing well today. So the new documents, there was a lot of new documents that have been filed, with all the glitches in the system and blah, 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 blah. It appears that those glitches might have been resolved. We'll see if there's any other major filing that comes in and the systems go down. We'll see. But there's only 3 documents that I'm really going to be kind of discussing today. And one of those documents is obviously the motion to dismiss the indictment. It's the most lengthy one of these documents that we're going to be going over. We're going to read it. I wanted to read it in its entirety But I have to be honest with you. When I was reading it, it was basically a history lesson. And I know that that's kind of what you do in these pleadings. You kind of give them the background of, the background of the law, you know, what historically rulings may have been, you know, different standards that, you know, may have different meanings, you know, depending, like when it comes to the indictment, they're alleging basically there's an indictment instruction and a, I know the word. It's like starts with a P. It's on the tip of my tongue, and I can't and I want to say it's procurement, but it's not. I don't know why my brain is falling flat today. Probably because I've been up so darn early. Hold on here. I'll let you know. Or remember it. But there's two different procedures in presentment. That's right. So the indictment and the presentment, there's two different kinds of instructions that need to be given. And so basically what they're arguing is that the jury was provided the wrong instruction, that they were provided the instruction related to I just said it. Lord have mercy. I need to shut this live down. I can't even think straight. So we have two different procedures, the indictment, and it's not the procurement. It's the, what did I just say? I don't know why my brain is shutting off on me. It's glitching out on me today, and I'm not sure why. But let me just say it. It starts with a P. Did I say it? I know. No, not presumption. I just said it. It's there's two different procedures here. One's for the indictment, and one is for the actual. It's like the evidence of. I'll look it up in just a second. I don't know why I'm telling you what. It's frustrating, and I don't know why my brain is shutting off on me. Like I've got all the. I should have wrote it down, but I knew I was going to remember it because it's something that's stupidly unforgettable. And I'm forgetting it. No, thank you, presentment. Lord have mercy. Let me write this down because I'm going to indictment and presentment. So there it is. Thank you. Thank you, Southern Grammy. So there's two different kinds of standards here, and they're basically arguing that they only were advised of the presentment, not the indictment, not the standard of indictment, you know, and they go in through here and do a lot of legal arguments, but all of which fall flat, because they're basically saying, you know, bringing in California law. They're basically saying that that California and Idaho law are similar in this field code adoption. And because of that, so they're trying to bring in some case law from California. Now, why is that important with California law? Because we know one of their expert witnesses, which happens to be an attorney, is primarily worked and practiced in California. So it seems like, you know, with all this California law, that they're relying heavily on her expertise to help them guide in this challenging of the indictment. But when they pull it back over to Idaho law falls flat. That means that they're not finding the law that they need to argue this case under Idaho. So they're bringing up California law in its place to kind of justify it, because they're probably going to argue that there's no real case in Idaho that will help establish their claims with this indictment. But they're challenging the indictment on the instructions provided to the jury. Again, this is where I said, for those that have been following this channel for any significant time, especially through the Bryan Kohberger case, you know one of the challenges is time when it comes to these high-profile cases. So you're going to definitely be trying to push forward. You know, the state's going to be trying to push forward while the defense is going to be trying to, you know, delay. And so even if she's not, which I don't think that this is going to be successful. I don't think their arguments are going to be successful on this indictment. I really don't. I think that this is just one, it is giving them something that they can go back on later to appeal. They can say that the judge ruled in error on this indictment. So she's setting herself up. She does not object to these things or argue these things at the time within her time frame. Then they waive the argument later. So she is making sure that she is going to be objecting every opportunity they have to object, so that those are so they're able to, at a later date, bring those to fruition in, say, an appeals type of situation. I don't think this is going to be successful, but if she garners any type of significant stay of the proceedings, she won, even if this fails, even if the judge denies her motion to dismiss, which he most likely will, just to let you know. I don't see anything in here, any arguments in here that are so that are not standard. Like I would expect this. So obviously the grand jury proceedings have been going on for many, many years in Idaho. And so I'm pretty confident that out of the hundreds of grand jury, maybe thousands, tens of thousands of grand juries that they've had over the, long before I was ever in existence, just seemed to be in error, right? Just seemed to be in error. So those are the types of things that I'm looking at. They're arguing things that have been argued before that have not proved to be successful. But again, it's giving them at least something to stand on later. If they don't object to it, they waive it. Which brings me to the next document, which is the second motion for stay. This is the one that even if she doesn't win on this document, if she gets this document, if she gets the stay, a full stay. Now remember, the first stay was partial. The judge cited that her request for stay was a little premature due to the fact that she had not had the transcript for the indictment, in that this would be the most appropriate time for her to do it. So she took the judge's advice, and now she's coming back to the judge and saying, hey, we need a full stay. So I'm just going to go over the indictment just a little bit with you. We're not going to read the entire thing because, again, a lot of these pages are just, oh, you're not seeing it. A lot of these pages literally are just explaining the history of the grand jury. It was a lot of boring reading. So I'm not going to subject my audience to it. We're only going to discuss a few things here, okay? I got to tell you, I took one for the team when reading this because I'm like, my eyes were glossing over. Usually that very rarely happens, but this was so boring. I was literally watching paint peel on the wall as I'm reading this. It really sucked. I have to be honest with you. So they start in the first 11 pages. They're talking a lot about California law, California this, California that. And then by page 12, they start dovetailing in California law and trying to weave Idaho law into the California standard. And I'm not sure if that's going to be successful. I mean, they bring up good case law. Don't get me wrong. Obviously, she knows what she's doing. But at the end of the day, it is you should really. It just shows me that there's not a good case law or good standard in Idaho, because that would be where she would be pooling all her case law. If they had case law in Idaho that supported her position in this matter, we would have a heck of a lot more supporting Idaho law as opposed to California law. And so a lot of California law explained in this Idaho document. And while it is proper, I mean, you can bring other laws in, especially in the lack of good, meaningful case law to support your claim. You can, go outside of that. But again, they keep, and I want to say she, but it's not. This was done by Jay Logsdon, which is the male attorney on the team. I believe he might be second chair potentially. So he's doing a lot of this research and such. And it basically saying that the failure to properly instruct the grand jury as to the standard of proof is grounds for dismissal of indictment. Now, again, this is, when you hear these pleadings and you hear this stuff, oh, excuse me. According to this document here, it's littered with arguments. It's littered with, you can't do this, you shouldn't do this, blah, 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 right? It doesn't necessarily mean that this is true, factual, accurate information. This is the argument from opposing counsel, from the defense, to the state. And just because they're saying it's true doesn't mean that that's how the judge is going to rule on the matter. Okay, so they're saying that because of this failure, this is grounds for the dismissal of the indictment. But so many of this, if this is grounds for dismissal of indictment, can you explain to me why so many of these that argue the same grounds are denied? Because just because they say it doesn't make it true. Obviously, there are proper instructions given daily to grand juries. They're challenged all the time. Most judges have a way of doing their grand juries, and they do it the exact same way every single time. They literally have a procedure behind that they follow, that they open the book and they go step by step by step, so they don't miss one single step when providing instructions or handling the grand jury. So it's kind of hard for me to believe that this is going to be dismissed, or that the grand jury was improperly instructed, which is what the defense is alleging. It doesn't mean it's true. It just means that's what the defense is alleging. That's what they're alleging. So this has to still go before a judge for a judge to decide, right? So it says, having shown the jury was provided with the wrong standard of proof. So they're alleging, again, they had 11 or 15 pages prior to this alleging the whole entire history of the grand jury, stating that, incorporating California law, then stating that the Idaho law has two different instructions, one for the indictment or whatever, and the other one is for the placement, or the placement or whatever it is. But we're going to get to that and make sure we have the right language. Okay. So, and then it goes into explain the field code. So this is the reason why that field code, that language related to the field code, is what they're standing on to help bring some of that California law into this pleading. And it says the field code adopted is somewhat complex interpretation of the statute permitting the defendant to challenge the indictment that the Idaho maintains for the most part. The grounds for setting aside indictment. Here's the information that we need to know about what are the grounds for setting aside of the indictment in accordance with the defense team. It says the grounds for setting aside the indictment. The indictment must be set aside by the court in which the defendant is arraigned upon his motion in either of the following cases: when it is not found, endorsed, and prescribed, and presented as prescribed in this code. It goes on to say under 2, when the names of the witness examined before the grand jury or whose deposition may have been read before them are not inserted at the foot of the indictment or endorsed thereon. When a person is permitted to present during the session of the grand jury, and when the charge embraced in the indictment is under consideration, except as provided in Chapter 11 of this title. When the defendant has not been held to answer before the finding of the indictment on any grounds which would have been good grounds for challenge, either to panel or any individual grand juror. So they're basically trying to push this into a preliminary type of hearing versus the grand jury indictment. They want to be able to argue the evidence, which the grand jury is designed to prevent to give an alternative to the preliminary hearing. A motion is, and it says that under 192408, A motion in arrest of judgment is an application on the part of the defendant that has no judgment to render on a plea or a verdict of guilty, or on a verdict against the defendant on a plea of a former conviction or acquittal. It may be found on any of the defects in the indictment that are grounds for demurrer. Unless the objection to the indictment has been waived by failure of demurrer, and I can't remember if that's the proper language, but I'll look that up, and must be made before at the time the defendant is called for judgment. Neither of the statutes was intended to create a mechanism for challenging the instructions given to the jury. So they're saying that neither of these statutes provide how to challenge the instructions. The Court of Appeals in New York found as much, but concluded that the defendant still moved to squash warrant where the proceedings intruded on their constitutional rights. I'm not sure this is an issue. Throughout this, I don't think she really raised his constitutional rights in this indictment. I mean, they give a lot of history, but I don't know how the grand jury indictment is somehow inappropriate. Free memberships when we reach 100 likes. Well, thank you, Sean. God bless you. God bless you. I don't know how many likes we're at, but we have 204 people in here. So please go out and give this a like. Put this up so you guys can see it a little bigger. Unfortunately, that didn't happen. Where a jury has been misled as to the standard to the defendant's detriment, court finds fundamental error because the error goes to the foundation of the case and takes away essential rights. So based upon this document here, you would think that Bryan Kohberger's rights were absolutely violated, that he has grounds, he should not be charged for this. And they're just going to throw this indictment out because an attorney writes a pleading alleging those facts. Well, just because they allege those facts doesn't make those facts true. So again, it comes back to whether I feel that this is going to survive. I really don't. I think the judge, after hearing oral arguments, will eventually deny this. I think during the time, he will go ahead and extend the motion to stay proceedings temporarily, potentially. But I think for the oral arguments, for the purposes of the indictment, I think that we will find that this will not be granted. This will be denied. They will not have to start the grand jury proceedings over. This is a very, very weak argument at best. And I just don't think they have the case law on their side for this to survive. I just don't. It also says presentment. Remember, indictment and presentment. There's two different types of instructions, and they're saying that they were only provided the presentment instructions. And it says presentment permits defendants to request a preliminary hearing. Pursuant to 19-1207, magistrate is to proceed on presentment as if it were an information. If it were an information, I don't know them. At first glance, this likely appears to undo much of what has come before. After all, a presentment is information that it already has had a preliminary hearing. However, history being what it is, things are not so simple. In 1887, when the revised statute were adopted, and information was the same as a complaint, revised, and it goes through the case law, an information or a complaint, and this is Idaho case law, FYI. Information or complaint is paper charging a defendant with a particular offense, and it matters not whether it is called information or a complaint. Once arrest on information, a defendant had a preliminary hearing referring to the time of an examination. It was not until the code was revised, certainly not for the first time, in 1969, that the terms became truly separate. So they're saying that since 1969 that this has been separate. And so basically all the instructions in Idaho since 1969, especially in this court's grand jury, must be wrong. So again, that's where I disagree on why I think this will fall flat. And it says in conclusion, over 150 years, Idaho joined the state of California, again trying to blend those case laws. Join the state of California in adopting field code, thereby adopting reform to the grand jury system intended to restore to the system its function as a bulwark of freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. Well, if it's unconstitutional, I'm sure the many challenges since 1969 would affirm her position on that, but it has not, because she's saying it has not, because it's both tragic and unconstitutional. No court had the power to decide that the legislature had made it too hard for grand juries to do their work and had to change the sufficiency of evidence required to indict. Mr. Kohberger, but they're not challenging the sufficiency of evidence required to indict. They're not challenging that. They're challenging that the jurors were provided the wrong instructions, or not provided inclusive instructions. All instructions is more what they're alleging. Mr. Kohberger is asking this court to recognize the long string of errors that led us here and give back the people of this state the protections that we are owed. This indictment in this matter should be dismissed or remanded for a preliminary hearing. Babe, you ain't getting a preliminary hearing. But maybe you might get that. Maybe you might get that motion to stay, which I think is this one right here. Yeah. So this one comes, now remember, the first motion to stay was granted in part, guys. It was granted in part. Judge said, we're not going to stay any of your requirements for discovery, for challenges, for anything. We're not going to, you still have to comply with the time clocks on those. But what we are going to do is we're going to stay Bryan Kohberger's speedy trial rights. So the clock stopped on the speedy trial. Why is that important? So according to Idaho law, from the time of the arraignment to the time that they bring this case to trial, they have 180 days or 6 months. And in that 180 days, if the state does not bring this to trial, then the defendant could potentially walk for a constitutional grounds of due process and speedy trial violations. So he could walk if they do not bring this trial in the designated amount of time. With that first stay, that it added 37 days to that speedy trial clock. So for example, we know that the trial is scheduled for October 2nd. Now the defense can add 37 days to that October 2nd date and push that well into December. So now their trial, in accordance to their speedy trial rights, would not expire until some date early December. I don't have a calculator, so I'm not calculating the, and it might be early or late November. It might be late November, early December, when right now, based on that partial stay, could push that back. And again, that is what the defense wants. The defense strategy is to delay. Some strategies might be to push push forward. If you don't think the person is prepared, you may want to push forward. But again, that might be a double-edged sword that will come back and bite you, right? And so this is something that you have to weigh when you're dealing with this, especially in criminal cases. So this second motion to stay proceedings, this is where I see she could potentially have a win. I don't think her arguments in the motion to dismiss the indictment, I don't believe they're strong enough to overcome the motion to dismiss. I really think it will be denied. But in an abundance of caution, while they're discussing these facts and having, preparing to have these oral arguments on this, I do believe that out of an abundance of caution that the judge will stay the proceedings, a full stay this time, as opposed to a partial stay. I believe he'll be more inclined to stay the proceedings. And that is the win for the defense. It's not whether or not this indictment is going to be thrown out. I truly believe that The defense is well aware that this is most likely not going to be the case. They're not going to be successful in this motion to dismiss, but that's not their end game. Their end game is trying to stay the proceeding and still maintain his speedy trial rights. At some point, when it starts getting too tight and too close to the trial date, you're most likely going to see Bryan Kohberger at that time waive his speedy trial rights, because then it would be advantageous for the defense to do so. Right now, it's not advantageous for the defense to do so. Or excuse me, it's not advantageous for the defense to do so at this moment, but there will be a time when it is. So they're going to be trying to hold the prosecution's feet to the fire to get as much discovery as possible. But, once that discovery is reached and there's nothing left, they're going to have to, strategize differently and figure out how the best way to delay this case. And typically those ways are by discovery request and motion to compel. So those really clog up the docket, and it really starts delaying, because you really want to have an open motion at that point on the docket at all times to prevent this from having to move forward. So the second motion to stay, it's a smaller one, so I'm just going to read this in its entirety. I'm not going to follow it. I'll just put myself up here because you're not going to be following it with I don't have the ability to, I'll read it from the screen. Hold on a second. Might be easier so you guys can all see it. Now let me see if I can make this a little bigger for you guys. Okay. I think that's good. So come now, Bryan C. Kohberger, Bryan through his attorney, Ann C. Taylor, public defender, and hereby makes the second request for stay. Idaho Code Section 2-213 provides for a stay of proceeding upon verified application of failure of Title II of the Idaho Code. Filed in conjunction with this motion, but under seal, is a sworn affidavit alleging failure of Title II of the Idaho Code. Title II provides statutory authority and requirements for convening trial juries or grand juries. Mr. Kohberger alleges failures of full compliance with Idaho Code Section 2-208. This statute states that individual must be randomly drawn from the county jury list, and that the jury commissioner shall draw a requisite number of qualified jurors for one or more panels or for a grand jury. This statute further requires, upon receipt of the direction and in a manner prescribed by the court, the jury commission shall publicly draw a random by use of a manual, mechanical, or automated system from the county jury list the number of prospective jurors specified. Idaho Code Section 2-208. The number of potential jurors appearing for potential selection impacted the seating of the grand jury that heard the case based upon review of the grand jury convening process. Apparent failure occurred. Idaho Code Section 2-2083 requires that qualification questionnaire form must be completed and returned to the clerk or the jury commissioner within 10 days from the date of mailing. The qualification questionnaire form shall elicit the name, address of residence, the age of prospective juror, and whether the prospective juror, A, is a citizen of the United States of America and a resident of the county, B, is able to read, speak, and understand the English language, C, has any disability impairing his capacity to render a satisfactory jury service, and D, has lost the right to serve as a juror because of felony criminal conviction as provided by Section 3. Article 6 of, is that Article 6? Yeah, Article 6 of the Constitution of the United States of Idaho, who has not been restored the right of citizenship pursuant to 310 Idaho Code or other applicable laws. The qualification questionnaire form shall contain the prospective jurors' declaration that his responses are true to the best of his knowledge, and his acknowledgement that willful misrepresentation of material facts may be punishable as a misdemeanor. Idaho Code Section 2-2083. Based upon review of the grand jury materials and process, it appears a failure has occurred. Further, other irregularities exist within the grand jury process, and further investigation is necessary to determine the impact, if any. So she's wanting to investigate. So this is the purpose of the stay. They have now alleged, good morning, Turkey Man. They have now alleged that there is issues with the jury, that there's issues with how they got the jury. They're now saying that there's other irregularities that they need to investigate as well. So this is where I see them having the advantage and being able to, if they are successful in this stay, it's a win for the defense team. I still think the arguments of the indictment will fall flat and be denied. But again, we don't know. There's no such thing as a slam dunk case. We all know that. So we don't know. She may have the argument of the year to establish her point, right? She may have, like, literally, she may pull something out of her pocket, and it just might be like, okay, well, she got something there, right? We don't know. Again, this is just what's being alleged by the defense. It doesn't mean that it's true. It doesn't mean that it's accurate. It doesn't mean that it's correct. It doesn't mean it's factual. It just means what they are alleging. It is up for oral arguments and for a judge to decide. And so, you know, and of course, defense, they're grasping, to me, looking at this case, they're grasping at straws. I don't think they have good defenses. We'll see. We haven't gotten there yet, but it seems like they're struggling, in my opinion, to find the alibi, to find that plan B, so to speak, right? They're trying to find a plan B. What is a plan B? It's basically, you know, finding somebody else to blame it on, right? They're trying to find their plan B. So we need to figure out what is, you know, whether he did it or not. But again, they gave us a pretty crappy response on the alibi. Wouldn't you agree? Like, the alibi response, we talked to it. It basically was no response. It was basically saying, we have no alibi. It was basically saying that through this, we're going to have a plan B, right? We're going to point to somebody else. He wasn't in the area at the time. The evidence, the discovery evidence and responses will conclude that he was elsewhere, but they never allege where else he was. And again, brings me to our next document, which is this one. And this one is the motion to compel. So the state is saying that was nonsense, right? That was, hold on. This is what the state says.
Bullshit detected. Take precautions.
Right? And so they say, wait a minute. That's not an alibi. That does not rise to what we are requesting. So the state says, wait a minute. You know what? That was not an alibi. We're going to compel your client. So they have now filed a motion. The state has filed a motion. Hold on here. Let me see if there's anything going on. I saw something pop up here. Give me a second. Okay. Thank you. Oh, we must have got to 100 likes. Thank you, Sean. God bless you. Sean just donated 1 Bullhorn Betty membership. So whoever received that membership, please thank Sean. Thank you, Sean. God bless you. It's always so nice. It's always so nice. And somebody gets and we're going to be doing something with the memberships. There are already some videos in there, but I'm going to do some special stuff. I'm not sure. I've been saying it for a while, but just have not put my feet to the fire and got it. But as you can see, we're getting a lot more organized. We're on several different platforms now discussing true crime. And we'll be continuing to build the channel, build the brand, and build the audience. So the state's basically saying that they're going to move the court for an order compelling the defense to comply in full with the Idaho Code 19-519 and ICR 12.1, and provide the state with notice of any alibi that may be offered herein. Said notice to include the specific place or places at which the defendant claims to have been at the time of the burglary and the homicides in this case, and the names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi. Now remember, the discovery process is not one-sided. It goes both ways. So the defense can't withhold stuff from the prosecution and an unfair surprise. So they're required to hand this stuff over to the state as well, so the state can look into the allegations and prepare. And in this case, they're saying that through discovery and responses that it will be established that Bryan Kohberger was elsewhere. They're saying that's not good enough. You need to provide more specificity. We have a right to examine these facts. We have a right to review the witnesses that are going to be establishing these facts on behalf of Bryan Kohberger. So as the court files reflect, the state filed a request for discovery disclosure, alibi demand on May 23rd, and served the defendant on the same day. The parties subsequently stipulated to extend the statutory time for the defendant to provide notice of alibi and comply with Idaho Code 519 and ICR 12.1. July 24, 2023. On July 24, 2023, the defendant filed a notice of defendant's response to state's alibi demand. This document does not comply with the requirement of Idaho Code 19-519 or ICR 12.1. In that it does not specify a place or places at which the defendant claims to have been at the time of the offenses herein, nor does it provide names and addresses of witnesses upon who the defendant intends to rely. The state recognizes that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. State versus Juarez, 169 Idaho 274 and 277. Taylor versus Illinois, 84 U.S. 400 410, 1988. However, as noted in both of these cited cases, the defendant's right to call witnesses in his or her defense is not unfettered, and the state has legitimate interest in obtaining timely and complete discovery response from the defendant. As I think it's Juarez. I think it's Juarez. Juarez. I think it's Juarez has observed if requested by the state during discovery, a defendant intending to offer an alibi must file a notice where the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses whose testimony will support the defendant's alibi. As evidenced by the defendant's July 24, 2023 notice of defendant's response to state's alibi demand, the defendant has failed to comply in any fashion with the requirement of the statute, court rules, and applicable case law. It is important to note that the scheduled October 2nd, 2023 jury trial is barely more than 2 months away. If the defendant intends to rely on an alibi, it is essential that they be required to provide prompt notice to the state so that the state can fully fulfill its obligations under the Idaho Code to investigate and respond to the notice of alibi. Now think about this. If he had an alibi, don't you think he would want to get himself out of this mess as quickly as possible? So wouldn't you think that it would behoove him to say, hey, I was over at Joe Plummer's house from this day to this day We were doing XYZ. I was not in the area at the time. Or I was over at Joe Blow's house and, his wife used my car and she was gone for a significant amount of time. It wasn't me. At this point, you would think that there would be some way of her defending her client with an alibi if he so had one. He was eager when he was arrested in Pennsylvania, eager to come back here and exonerate himself. And you would think that a man would have an alibi, even if he was home alone, sleeping in bed. That's an alibi. So why hasn't he said he's home? Where was he at that time? She's not alleging he was at home. She's alleging that he was somewhere else. Okay, where was I? The state also noted, as the United States Supreme Court observed in Taylor versus Illinois, the ease in which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. The adverse system of trial is hardly an end in itself. It is not just yet a poker game which players enjoy the absolute right always to conceal their cards until played. Based on the above, the state respectfully prays that this court prays for the court for an order of compelling the defendants to comply with the rule. It says filing a notice specifying where the defendant's claims have been made at the time of the alleged offenses, the names, addresses of witnesses whose testimony will support the defendant's alibi, give the time constraints. The state prays that the court direct the defendant to comply no later than 10 days of the order. So that's where they're at on that. So we've got several different major motions that are outstanding right now. We have the motion challenging the indictment. Now, there was a laundry list of other stuff, orders sealing this, sealing that. I'm not getting into or printing that out. I waste a lot of paper. And so now I've been very cautious about what I'm printing out and what's going into the binder for this case. And so it's only the stuff that really has the legal arguments. I'm not, they say the same thing in these stupid orders and sealments that somebody's going to die if they disclose it. So, I digress. Either way, I'm not paying attention to those. But I am paying attention to the meat and potatoes of what they're arguing. And so the stuff that came out yesterday was the challenge of the indictment. They want a full stay of the proceedings, the defense does, and then the state is demanding that the courts compel the defense to provide the alibi or waive their ability to bring witnesses to substantiate his alibi claims. So I have a funny feeling that it's not going to get there. I don't think they're going to be able to alibi him. He doesn't have a whole lot of friends. He wasn't with somebody at the time. They're only going to be able to say that he was alone somewhere because there's not going to be anybody to help him. And even if there is one person that then say, oh, he was here, they better have a lot of darn proof to prove he was there, because remember, there are cameras all over from Wazoo all the way to the University of Idaho. There's traffic cameras literally everywhere. It's college towns. They're responsible for people's kids. They're young adults, but they're still people's kids. They're still considered, kids even in college. I don't know why we don't consider them adults when they go to college. We typically consider them kids. There's somebody kids. When we go out there and people were fighting, what were they saying? People were yelling at them that how can you attack these kids, right? So they're learning, they're getting out of their skin and learning new things, being, many of them for the first time being on their own without their parents. There's going to be some little wild, explorations and stuff like that. That's understandable. But at the end of the day, the universities are responsible for their pupils. And so there's cameras literally flipping everywhere. So he's better have some major evidence to prove that he was somewhere else. Because remember, he decided to turn his phone off. So he's not going to be able to prove he was somewhere else by his phone. But they can prove that his car was in and around that house at the time of the murders. There's going to be a problem. Just saying. They've got to overcome it. They can allege anything in these pleadings. They can allege that he's a saint and a pastor or a preacher at a Catholic. What is it? pastor or preacher at a church, right? They could literally allege anything in these pleadings. It's whether they can prove it. That's really the crux of this. And I just don't think for the motion to challenge the indictment, I don't think they're going to be able to prove their claim. Not as appropriate as needed. So now comes to the time where we've gone over a lot of stuff here. I know this is legal mumbo jumbo, so I try to parse it down to at least edible, digestible language for you guys. I know it's still a lot of legalese, and even I myself talk in legalese sometimes, but I hope at least I clarified. Now, just because my opinion is that the indictment's not going to be successful doesn't mean that it's not going to be successful. Just the probability of success. I mean, they're arguing the same. This is the way I look at it. They're arguing the same arguments that many other people have argued, and they weren't successful. So why would this argument all of a sudden today now be successful? August 18th at 10:30, and then we had this one here. They vacated one of them. One of the I know they vacated one of the notices of hearing, but this newest notice of hearing is August. Yeah. So August 18th. You never know. I might be in town. I might be in Idaho August 18th. I have no earthly idea. I know I'm planning on going to Idaho in the month of August. That's what I know. Now, will that come through? I'm unsure yet. I'm working on the details now, but it looks like sometime in August I will be in the Moscow area. So that should be interesting. Seems to me the evidence shows a spite-filled, hateful violator of human life and needs to be held accountable. God bless you, Kelly Sue. Yes, I agree. And it is, with the fighting of this, the alibi and not producing the alibi. I mean, it really, in my opinion, takes the wind out of the sails of the folks that believe he's not guilty. To me, it does, because if he was not guilty, why is he playing word games with his alibi? Why is he playing word games with his alibi? I mean, if he was somewhere else and he should be able to prove. I am here all the time by myself, right? I don't have anybody to corroborate my comings and goings. Nobody. So if I was charged with some kind of violent crime and I was home with no witnesses, does that mean I have no alibi? Of course not. Could I prove that I was home? Absolutely could. I absolutely could. You want to know how? Because I know that no matter where I leave on 57th, there's a camera, traffic camera installed everywhere here in this county. Everywhere around, there's a traffic camera. So I have evidence that I didn't leave my home, right? But hey, I could have borrowed the neighbor's car and left. Okay. Well, then the neighbor would know that, right? The neighbor would be able to come and testify against me, right? So there's a number of things that even if you are completely alone, all by yourself, I guarantee that my behaviors day after day are very consistent, day after day, week after week. So I'm predictable, right? In the eyes of the law, if they were wanting to monitor my movements or whatever, I would be considered predictable. Basically, I do the same thing over every day, every single day, with some nuances. I might have this meeting over here, blah, 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 blah. But for the most part, I get up at a certain time. I work early in the mornings. I do a live. I do some videos. I do legal research. I do all this other types of research. And, then I go to bed and do the same thing over and over again. So if for any reason, one day that somebody around me or I knew that I was angry with, or for whatever reason, all of a sudden I'm in their area, I'm turning off my phone, I'm doing things that aren't typical of me. That's also evidence against you. If I can show that for 6 months or the entire time I was at wazoo. I've never turned my phone off once. There's no evidence of me turning the phone off, to stop the pings. And then all of a sudden, the day that 4 people die is the day that my phone is turned off. That's evidence. That is evidence against somebody. Look at their behavior. Their behavior was inconsistent the day that this happened. So, anyways, that's just my take on it. I'm interested in yours. Give me just a second as I'm pulling up. So for those that would like to call in, maybe, give your point of view, the number is 724-249-6140. If you'd like to call in and just let me know your thoughts on this new information, this is where, the case is kind of, dying down a little bit because we're dealing with the legal stuff, and this bores a lot of people in true crime. They're not interested in the legal part of it, but this is the case. This is the stuff I'm interested in, at least. And apparently, at least some part of my my tribe here, right, is interested in. We have almost 300 people in the chat going over these very legal documents. So it's not the fact that we are not. It's just a lot of boring stuff. I don't blame the defense for delaying prosecution, playing games. Oh, no. This is part of it. This is a lot of people that don't watch this stuff day in and day out. They think this is like jaw-dropping stuff. Oh my God, they're trying to look. It's not. This is like, for somebody like me, this is standard operating procedure. This is nothing that I get too excited over or anything like that. That's why I try to explain it to people, because I understand that if you don't challenge certain things, you lose the opportunity to challenge it later. So the attorneys have 2 different things that they're working on. They're working on maintaining their case, their actual trial case, but they're also having to make sure that they're timely objecting to certain things, or giving their, making sure they make claims that they can use later down the road, say during appeals process, because if they don't raise an objection or a challenge, it would be moot. If they don't challenge it in the proper time frame, they will be prevented. They would be barred from challenging at a later time. So a lot of this stuff, whether it falls flat, whether it doesn't have legal sufficiency, might be used in an appeals process down the road. So while we don't understand the legal strategy from the defense, we're kind of seeing a little bit as the pleadings are coming out. But at the end of the day, they also have to protect their client post-conviction. There's got to be challenges post-conviction. And so they're setting up those types of things as they're preparing this trial case. So, we heard in Alec Murdaugh's case, 404 and 403B challenges and stuff like that, where it's evidence that could be prejudicial. The probative value doesn't outweigh the prejudice and things of that nature. Those are things that they have to challenge at that moment, because when they get down to an appeal, the appeals court will say, well, you had an opportunity to challenge it and you didn't. And so they've waived their challenge. So that's why a lot of these things, maybe we don't understand. We're like, wait a minute, this doesn't make sense. This isn't right. This didn't happen. They have to do it. They have to do it. But I think her goal in this is the stay. The way I'm looking at this, her goal is the stay. Her goal is not to throw out the indictment. I think she, as a seasoned attorney, knows that her indictment, and Jay Logsdon for that matter, knows that the indictment is weak. It is weak. I mean, it's 21 pages of a bunch of history, a history lesson. But at the end of the day, it's a weak argument. There's no ifs, ands, or buts about it. It's a weak argument. Thank you, Lulu's Niana. God bless you. God bless you. And I see one from, did I miss you, Jennifer? Did I put yours up here? I saw you. If I didn't put you up here, I'm so sorry. I see you at the top, but I can't find you in the list. Oh my gosh. Oh my gosh. Oh my goodness. That was a super sticker. Oh, you know what? So I can't see the super stickers on this side anyway. So let me go down to the bottom here. And I'm going to go over to the other side and see what you guys have been sending me. Oh, number one fan. Oh, thank you. Oh, look at all this. So Sean gave me a kissy kissy. Jennifer gave me a unicorn. Sean, we did meet the 100 likes, and she did provide a gift membership. B Betty fan, 15-month member. God bless you, B Betty fan. God bless you. And it says, hi, BHB and Coffee Club. Heart, hit the like for the best. For the best host ever. I love her little emoji that she's explaining. That's so cute. Leaf lover Liz. Oh, you're so sweet. 1 month member. Happy Friday. Oh, shoot, it is Friday, isn't it? I forgot I missed Thursday. I think I started off this morning on my TikTok saying happy Thursday instead of TGIF. Oh my gosh, I missed the day, TGIF. So Liz Leaf Lover says, happy Friday. My daughter Sailor turns 3 today. Oh, I love that name, Sailor. Oh my gosh. You know, that brings me to a case. But happy birthday, Sailor. Happy 3rd birthday. You are officially out of your terrible twos. Mommy couldn't be happier. I'm sure Mommy's doing a happy dance. Come on, Leaf Lover Liz. You know, you've been pulling your hair out for the last 12 months and you're happy. That number 3 is like, you've been waiting for the pearly gates, right? And you get that 3 and you're like, oh, we're almost to the end goal. We're almost out of the terrible twos, right? They're not quite out of the terrible twos when they turn 3, right? But you see the light at the end of the tunnel. People are like, you don't have kids. You don't know anything about it. I raise grandchildren, okay? I may not have birthed a child, but trust me, it doesn't take a rocket scientist to realize what a terrible 2 child acts like. And let me tell you, I'm one of those grandmas, when they don't get their way and they start kicking and screaming in the middle of the aisle, I walk away. I'm not going to get embarrassed with you. I'll look, point, and laugh. I'll see you later. Start walking. Trust me. You can say I'm not a parent, but I tell you what, I don't deal with all this disrespect from kids. You know, my grandchildren treat me with respect. I don't know about y'all. I know the people in my chat, they probably school their kids. 3 is worse than 2. Oh no, we love her, Liz. The parents are speaking. The parents are speaking, right? Ah! No, the 3s, when she turned, oh God, good Lord, when all of the grandchildren turned 3, my Lord, you're right about the first, but then they start getting excited about stuff else. So trust me, the 3s, the terrible 2s start dissipating. I promise you, they start dissipating. My grandkids didn't get worse at 3. They started getting a little more curious, and I actually was able to keep them occupied more, which, you know, brought down that screaming and stuff like that. Sailor, happy birthday from the Bullhorn, Betty Cruz. So if my audience could be putting some birthday cakes and some stuff up there for Sailor, wishing her a happy 3rd birthday from the Bullhorn Betty channel to you. Do I get to spank her 3 times? There we go. And a pinch to grow an inch, right? And a pinch to grow an inch. Happy birthday, Sailor. God bless you. All right. What else do we have? Sean gifted a Bullhorn Betty membership. Robert's Girl, a 12-month member. OMG. 12-month member. Yay. Love you, BHB mods in chat. Well, God bless you. Only 9 months on vacation, so not been here much. Love to you all. And Lula's Nana was a number 1 fan with a bouncing guy. It's a number 1 fan. I love it. You guys melt my heart. You really do. God bless you guys. God bless you guys. But definitely keep Sailor in our thoughts today as she turns 3. Don't worry, you only got 12 more months. 12 more months. 4s are much funner. 5s, I think I had the most fun with my grandchildren when they were 5. You know, they have their own, like your kids have their own personality anyways, but they're kind of able to understand a little more. They're able to keep up with you a little more. And they're still ultra, ultra curious. So that moment when you teach them something new and their eyes brighten up, it's just, I don't know. I love kids. I think it's so precious. You know what I love the most about kids is their curiosity, their love for adventure, just learning new stuff. I think as we get older, we lose that curiosity. I just feel like, I don't know. I just feel like we forget to have fun. And you know, when we grow up, you grow up, right? But there's a lot of people that know how to grow up and still have fun. For some of us, it's a challenge, right? Like for me, I ended up going into law. It's so serious. Like I lost my sense of humor. Every person I was around had a dry sense of humor. Like their jokes sucked, right? I lost my sense of humor. But it is. So anyways, guys, the phones are open. It's awfully quiet here. If you guys would like to call in, you can. But that really is pretty much the show. I really don't have a whole lot more to go over today. Well, I guess that's not true either. That's not true either. There's been some, you know, Michael Monkey Vaughn, you know, we went out there and covered his case in Idaho. And there's some movement on the case, and guys, it started the way it sounds, and I'm kind of reading between the lines, but this is one of the lines that I'm not sure if I'm reading it correctly. I think I am, and I'm hoping I am. Hold on. Let's see here. Why am I not finding it? Having a hard time looking for what I'm looking for. Following. All right, so let me go over here. I'm going to go ahead and shut the phones down so I can move on. I don't want to accidentally dox people, and when I'm sharing these screens, I can only have the phones on, and once I start sharing the screen again, I have to turn it off because it will have problems and could potentially dox if somebody calls in while I'm reading something. So I just want to make sure that we don't do that. All right, so I'm going to go ahead and share this tab, and we're going to pull it up and just read it because this is on Michael Monkey Vaughn. Let me go ahead and, is there any way to make this bigger? Okay, so here is what it says. Let's see if I can make it bigger. Can you guys see that? Yeah. It says, update, the search for Michael Joseph Vaughn. We know him as Monkey Vaughn. The search continues for Michael Joseph. I'm just going to say Michael Monkey Vaughn, now age 7. On the 2nd anniversary of Michael's abduction, the case remains very active. Our work has not stopped. Our ground searches have continued as recent as this month, and we continue the arduous task of filtering through new tips and leads. This investigation is moving into a new phase as investigators have submitted this case along with a probable cause affidavit to the Payette County Prosecutor's Office. Oh my gosh, there may be indictments and arrests coming, guys. Let's say a prayer for the family. This investigation is moving into a new phase. As a result, any inquiries regarding this case will be referred to the Fayette County Prosecutor's Office. So they're no longer going to be communicating about this case as it goes into the legal aspect. Now, remember, there were 4 suspects named: Sarah Wandra, Stacy Wandra, Adrian, and Brandon Shirtlift. I can't remember what Adrian's last name was, but I said it yesterday or the day before. It starts with an A. It's a long word. Adrian, or not Adrian. It starts with something else. I can't remember the last name, but Adrian something. So they give the number. So if there is any inquiries, call the prosecutor's office. The community support has been remarkable, along with the unwavering patience of our team. We are committed, and our tenacity is steadfast. To date, the Fruitland Police Department has received over 2,000 tips and leads. If someone has or learns of information that can help find Monkey, we want that information. We continue to ask that you remain vigilant and please share the post. So we also saw that Michael's face was on the back of the tractor trailers. And I really think they have a thought there. You know, our tractor trailers, you know, before it was milk cartons. We no longer do milk cartons. We no longer do paper milk cartons. We use plastic milk bottles. And we stopped. Tomorrow's ZA's birthday. Well, happy early birthday, ZA. We're going to have to remind me so I can say happy birthday to you tomorrow. God bless you. Oh, that's so sweet. You know, and this goes, anyways, getting back to Michael. So they really do have something here. I really think, you know, in lack, because there was a lot of people that were snatched at younger, they found themselves on the back of milk cartons. They were able to go home to their parents, or, you know, they knew something was odd growing up or whatnot. And, you know, there's been multiple, not just a few, multiple people that found themselves, you know, identified this child that they remember as themselves on the back of a carton. But now, you know, with the tractor trailers, we don't have that opportunity. But what do we have? You know, tractor trailers, the 18-wheelers are literally all over this country, right? They are all over this country driving. Boy, what an impact that would have across this country, seeing missing persons on those tractor trailers. How those could really help provide solutions, because even bad people that are taking these kids and stuff, they have to move them around somehow. Can you imagine a child seeing their face on the back of a truck and knowing that there's help and people never forgot about them, how impactful that is? And I really think, you know, in this day and age, we need to have something like that. I think that was such a brilliant idea. And I got to see the first trucker with his face on it, and that really melted my heart, you know. And I think it's something we can do for a lot of missing people. You know, those tractor trailers, I know it costs money to get those things printed on the tractor trailers. I get that, but we have, you know, nonprofits and stuff that help, you know, with those things. I can tell you, over the next year or two, we're going to be building a nonprofit for this channel. We're going to be building a nonprofit to help with those very types of things, help, you know, raise money, help get those things out. So we'll see how all that transpires in the years, you know, that as they unfold. We have to do this in piecemeal. We're not at that point yet. But again, when I started building this channel, I had an eye in mind on how I wanted it to be. But you can't just do it all at once. All you can do is go in stages and one step at a time. And that's how we've been building this channel. Either way, I want you to know what is going on in Michael Monkey Vaughn. I have literally heard no word as to whether Carly Russell has been arrested or not. For whatever reason, there's just something in my gut telling me she went to a mental hospital and has been checked in. Because really, this type of crime, they're not going to, you know, force the person out of the hospital or get a court order to arrest them. They'll just let them, you know, obviously there's emotional issues going on with her. She needs to address those things first and foremost. And but for whatever reason, I just feel like, because I remember hearing that if she went to, they would postpone the arrest. And I heard that in the back chatter even before we heard from her attorney. That's what I was hearing. So how true that is, I have no clue. Again, leave Michael Monkey Vaughn in your prayers. Leave his family in your prayers. I remember when we first started hearing about the case, I really didn't kind of jump in with both feet because I didn't know how to take it. I was getting so many mixed signals. So there was people that were telling me that Brandy or her husband or her boyfriend, they live like husband and wife. They've been together forever. They just never got married. So I don't know how to explain it. They're a significant and lengthy couple. Okay. And so I really didn't know, at first I fought and said, look at how Brandy's acting compared, because she was my comparison. Their family was my comparison against, say, Don Wells and Candace Bly, because you saw the crap that they were doing. They were literally doing nothing to help find Summer. And then you look and Brandy's, Michael Vaughn, Monkey, disappeared only like 15 days after Summer Wells did. But you saw the level of tenacity and perseverance that his mom did. His mom had to go to work. She had to get up. She still had to coordinate searches. She had to coordinate people putting flyers up. Like, I kept comparing her and Candace and showing you see what a family that most likely had something to do with their child disappearing versus a family that doesn't have something to do with their child disappearing. And then as time went on, some people were saying, well, let me tell you, Tyler he's been acting weird. He's been acting funny. And of course, I asked somebody else, and we can, and I explained it like this because, he was acting funny. I don't want to dispute that. He absolutely was acting funny. Everybody's noticing of that was rightfully so. They had a right to say that yes, he was acting funny. I can admit he was acting funny. And then I brought back to Stephanie Shenefield. When we went out searching for her, she was the bartender here in Manatee County, and her roommate, they were very rough. Not very rough looking, but they were very rough. They lived a very rough lifestyle. They were on a massive amount of really, really harsh drugs. And they lived in a house. So like 4 or 5 of these people lived in the house together. Her roommate, which was a very, very smart guy, that was well-educated, that turned his life to drugs, tattoos, and motorcycles. He was missing teeth at the time, but a man that was well-educated at one point in his life and could have done amazing things, turned, and they were in this house. Well, I think at some point he started thinking that he might be thrown under the bus because of his appearance, the way he looks, whatever. And then he started acting really, really weird. And there was more media, and the more media showed up, the more he wanted everybody just to quit talking because he felt like everybody was looking at him. Everybody was going to be pointing the finger at him. So he started acting freaking weird, red flags, everything. Ends up getting on his bike to drive off and almost drives it into, like, so nervous he almost drives it into a freaking pond, right? Red flags, right? Right? It's because he had so much pressure, and he psyched his own brain out thinking everybody is going to think it's him, that he ended up making himself look guilty just because his conscience was eating him alive. He had nothing whatsoever to do with Stephanie Shenefield's disappearance or death. Nothing at all. But you looked at his behavior, and especially when stuff started, the more media showed up and he getting scared and getting on his bike and getting the heck out of Dodge and almost driving it into a freaking lake because he's so nervous. Yeah, that to me seems like somebody that's trying to hide something. But it wasn't. It was his nerves. And the reason why I go over and explain this very case to people is because I think that truly is kind of the explanation of the weird behavior we saw from Tyler. And I even explained this at the time, because I'm like, is Brandy telling the truth? Is she not? And I'm like, I had been talking about and comparing her to the Wells, that I did not want to believe that she was responsible or her husband was responsible. But her husband was acting weird. We all saw it. We all noticed it. There's no ifs, ands, or buts about it. So I wanted to go out there and get a lay of the land, and I just couldn't. This is another one where I didn't have enough information to say one way or another. I can tell you, as soon as I went out there and did my fact finding, went around there, posted flyers, talked to neighbors and everything like that. There wasn't a stitch in my mind she had anything to do with her son's disappearance or Tyler. There was not a stitch in my mind. I talked to neighbors that saw her at that moment. I remember one of the neighbors, I've got him on interview. One of the neighbors down the road said they saw Brandy at that, the park, the water park there. And she said she thought she was looking for her dog. And she even said, like, I had never seen a woman looking for that dog. So, this dog, like, she said her face, her demeanor, she said she was frantic. Like, I'm getting goosebumps, like literally getting goosebumps just telling the story. And she's like, I saw her frantically looking, and I'm thinking, wow, usually dogs around here just run home. She's really looking for this animal. And she said, I just happened to think about that. She's like, I went on with my day. I walked my dogs and didn't think anything of it until later. And I realized she was searching for her son. She goes, my heart broke. I talked to another person that said that within, them calling law enforcement, they had drones in the air. I met with the gentleman that had that huge drone that got shot out of the sky out there while searching for Michael. I had an interview with him, met with him personally. And it was a good interview. So it was like, if anybody would have just taken their time to go there and do their due diligence, there was no ifs, ands, or buts in anybody's mind whether or not Brandy had anything to do with it. Brandy, I can honestly say, was terrified to meet me because everybody had called her and lied to her about who I was and what I do. And she was literally expecting me to protest, which again, I've only protested out of all the cases I've covered 3 times, and it's protected by the Constitution. I'm sick and tired of hearing any more garbage about this whole nonsense. If nothing else, that is one thing that is absolutely 100% protected under the Constitution of the United States of America. So I really could care less whether people approve it or not. I have the Constitution on my side. No ifs, ands, or buts about it. But she was so terrified that I was going there, which I've done 3, literally 3 in true crime. 3. I've done hundreds in political, 3 in true crime. And it's like the world is falling apart, right? And they lie to these people and tell them that I'm coming there to protest, which is an absolute lie. I'm going there for fact finding. But listen to this. After all that nonsense that people told her about me, that I'm going to go there and I'm just trying to catch her, which is not true. I'm trying to find the truth and report the truth back. That's what I'm trying to get to and seeing if I can help. Now, remember, we've posted hundreds of flyers in the community. We posted a banner out on the main drag. There was no banner there. Well, there was a sign, but not a nice banner there for Michael or his photo on it. And we put a big, huge banner out there with his photo and told them how they can help and call in tips for this boy. And Dolly made it in bright, beautiful colors so everybody could see it from the roadway. It was gorgeous. We were able to do that. That is called helping someone. Okay? Putting up flyers, putting up signs. That's help. That's one thing they didn't have to do. But you know what the crazy thing is with all of this chatter and people saying, oh, you don't want to meet Betty, because they wanted to keep their channels with Brandy on it. They wanted to exploit Brandy on their channels as their friend. I didn't. I went out there for an interview. I didn't exploit her. I met with her. She agreed to meet with me, and she gave me and Dolly both an interview. And you know what? I got to hug her, and she finally got to see me for me and not this made up story from these other people. Then I find out some information which was provided to me through normal channels, and her so-called friends ended up calling her, recording her, telling her the worst news of her life on their live TV, and then turning around and trying to blame me for that. I didn't do that. You did. And that poor woman had been through hell. But just think about it. I have yet to even meet with Don or Candace for an interview. And Brandy, which all these haters told her I was going to be deceptive, I was going to do this, I was going to do that, and she was literally terrified of meeting me. And that woman still sat down to meet with me if it could help find her son. And there's your difference between a family that has nothing to do with their child's disappearance and a family that does have something to do with their child's disappearance. People keep asking me, why do you think that Wells did it? Because they did. I'm sorry, you don't know, and you didn't do your fact finding. You didn't spend the money. You didn't go out there and research this case. You didn't interview a damn person other than Don or Candace. Who, right? I'm sorry, those channels chose not to do to do the due diligence. And I'm even more shocked that they intentionally lie, deceive, and con money out of their own audience to go help pay for the drugs and the alcohol of Don and Candace, which I think is sick and demented, especially everything they've done to all of their children. All of their children. The abuse, the 40 years of abuse against all of their children. And people are supporting them financially, allowing them to go out and even destroy their lives even more instead of taking care of their kids. Just a thought. But hey, I'm the bad guy, right? Dolly is so funny. I watched him last night from the bushes. Oh, really? I haven't watched him. Oh my gosh, I got to go back and watch. I bet you it's hilarious. I bet you it's hilarious. He does. He makes me laugh. He makes me laugh. I go in there every now and again, and I'll listen for a little bit, but usually I move on because I have a lot of crap to do during my days, and yesterday was no different, but I'm thankful I have light. I'm thankful I have light in here. All right, guys, we're at the top of the 2-hour mark. We're just a little shy. We'll be back later to discuss more as information becomes available to me. I hope you guys have an amazing Friday. TGIF. Guys, please don't forget Michael Monkey Vaughn, 2-year milestone here today. His family is probably heartbroken at this moment. They have to live this every single day, but I am praying justice is served. I want to be there for this hearing, for this trial of this little boy. I want to do whatever we can, as loving as we can, to support. Now, let me tell you guys another thing. Everybody says I'm so nasty. Can you guys explain to me why Fruitland, Idaho, I was there, right? I made multiple trips to that area. Why no protest? Why no protest there? Why? Oh, because the law enforcement was doing their job. Family's not involved, right? So what do we do at that point? We advocate. We put his name out there. We put videos of him out there. We put his face on things, right? So why was there no protest for Michael Monkey Vaughn? If all it is for clicks and views, right? Why? Because we don't use that strategy for every single case. And yes, it is a strategy. Just like any other protest, right? What is the strategy? To bring awareness to the injustice. Our entire life, we have watched protest after protest after protest litter the streets across the United States of America. But for whatever reason, when a group of people go out there for an injustice against a child, it's somehow wrong, somehow unconstitutional. Are you idiots? Just curious. Just curious. Thank God my job is protected by the Constitution of the United States of America. That's a pretty damn good defense for my job, isn't it? Imagine that. Imagine that. All right, guys, you guys have an amazing day. God bless you. Thank you all again for your beautiful and loving support of this channel today. And just for those to go out, I'm giving a big thank you to Sean, Jennifer B. Betty Fan, Leaf Lover Liz, Only M, Lulu's Nana, ZA. Thank you all so very much for all your love and support this beautiful day. TGIF, God bless you. And I hope you guys stay amazing, as I know you will. And if you guys have any questions on a case that you would like answers to, or maybe a discussion on a specific topic, just for clarification for your mind, send me an email of a potential topic you would like to discuss. If there's something like maybe you don't understand a pleading that's going on in the Bryan Kohberger case, or you don't understand a specific, whatever, something's going on in another case, send me an email. I'll do the research on it and I'll get you guys the answer. And if it's something that I think the entire audience is interested in hearing, I'm happy to do a live on that very specific thing. And you can reach me at bullhornbetty@gmail.com. bullhornbetty@gmail.com. Guys, you rock. I want to let you know, please don't forget to be fearless. If you see something, say something, because an ounce of prevention is worth a pound of cure. And until next time, y'all be kind to each other, right? Be safe and kind to one another, especially in the comments. All my replay crew, all the Debbie Downers, all you guys, be kind in the comments section. Otherwise, it'll be removed, right? That's the rules. So if you guys want to come in here and be rude and be nasty in the comments section, don't complain about your comments being removed, because they will be removed if they do not comply with the rules of the channel to comment. Simple as that. Take care.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.